Good day, Crime Talk aficionado. We have another great show for you today. First, the mother of the missing California girl, Ashlee Buzzard, well, the mom, Ashlee, she appeared in court. The family of Idaho student murder victims announced they intend to pursue a civil action against Washington State University. We'll talk about that. A fugitive Florida sex offender captured in Indiana after 16 years. Little charade there that took even a fake suicide. A married mother and school employee admits to, going after an 11-year-old boy with caffeine so she could repeatedly do inappropriate things with him. We got an ex-South Carolina lawmaker released on bond amid some serious allegations of client betrayal. A former Canadian Olympian indicted on federal charges of murder and drug trafficking. We've got This Day in Legal History, our quote of the day regarding why we have good lawyers, and then our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get to the docket, we need to do a little business. All right. Got to pay the bills. So go to crimetalksearch.com, sign up for a background subscription service. You say, Scott, why do I need a background subscription service? Because there are people out there that do bad things. And if they're coming into your life, you need to make sure that, well, you know about it, right? If there's something about somebody you want to check out, maybe it's a school teacher, maybe it's a neighbor, maybe it's the parents of those, the kids that your kids are starting to hang out with, and they don't give you that warm, fuzzy feeling. Go to crimetalksearch.com, get a background report done literally while you wait, and you can do as many reports as you desire. Criminal history, social media presence. You're going to find out if people are married, divorced, do they own property, do they have judgments against them. Everything you want to know about somebody. All right, go to crimetalksearch.com. Also, Christmas is coming. It'll be here before you know it. And what do you want? What everybody wants. Crime Talk gear. All right. Now, this is just a quick sample of some of the Crime Talk gear that we have. There's more. You can get them there at the website and the link below. Yes, go there. Get this. Who doesn't want to walk around? Everyone in my office has these Crime Talk tags on their briefcases, their bags. Just show it was the hottest thing at CrimeCon. I swear everybody wants them. All the cool kids have them. They're $5. You can't go wrong. And we'll ship it to you. All right, let's go ahead and open the record for Thursday, November 20th, 2025. And first on the docket. So the mother of a missing 9-year-old California girl described as at risk appeared briefly in court Wednesday on a felony false imprisonment charge completely unrelated to her daughter's disappearance. Now, police in Santa Barbara County, California, have charged Ashlee Buzzard with one count of felony false imprisonment stemming from an incident involving an adult male victim. The charge is explicitly unrelated to the ongoing investigation into the disappearance of her 9-year-old daughter, Ashlee Buzzard, who has been missing since October of this year. Now, the false imprisonment allegation arose from events reported on or around November 6th of this year at Buzzard's residence. Now, according to police statements from the Santa Barbara County Sheriff's Office, Buzzard is accused of preventing the victim from leaving a location against his will, i.e. the house. The victim, identified in public reports as Tyler Brewer, a court officer acquainted with Buzzard, stated that he visited her home to discuss the search for Melodee. Brewer alleged that after Buzzard shared certain information, she displayed distress, locked the doors, and retrieved a box cutter, thereby restricting his departure until she later permitted him to leave the residence. Now, Brewer subsequently contacted law enforcement and told them what happened. Buzzard was arrested on November 7th and initially held on a $100,000 bond. She pled not guilty to the charge during an arraignment on November 12th. Following the hearing, she was released from custody under supervised conditions, including the requirement that she wear a GPS ankle monitor and have no contact with the alleged victim in the case. Now, a preliminary hearing during which evidence will be presented to determine if the case should proceed, i.e., is there enough evidence, probable cause, would a reasonable person believe that a crime was committed and that the defendant had something to do with it. Very low standard of proof, not proof beyond a reasonable doubt, and it's a screening device, obviously, for serious cases to see if they should go forward. Anyway, the sheriff office has emphasized that this criminal matter arose during the missing persons investigation, but does not directly pertain to Melodee's whereabouts. Now, Buzzard's defense attorney has indicated a readiness to challenge the accuser's credibility in court. And this development occurs amid an intensive search for Ashlee Buzzard, who was last confirmed sighted in early of October of this year during a multi-state road trip with her mother. And as of November 20th, no charges have been filed against Buzzard in connection with her daughter's disappearance, and the child remains classified as missing and at risk. Now, the Federal Bureau of Investigation continues to assist local police in this effort to locate her, and obviously no sign of her. Now, like we mentioned yesterday, these kind of cases come up. We saw this in the Lori Vallow matter, right? People are saying, where are the kids? File something. Send her a ticket to produce the child at truancy court. Do something to force her to have to speak. All right. Even if you show up at truancy court, where's your kid? It's really kind of a civil type of thing. Do you really have? I guess you could assert the fifth, but certainly you could do something. Start a DNN saying that you're a neglectful mother. Produce the child. Eventually, it'll prompt them to try to cut a deal, try to work something out for themselves to help save themselves. I don't understand why. I don't know. California is just a weird state. It's a weird jurisdiction. Some things they jump all over. Other things like this, they seem to just kind of take their time. Not to mention, the singer David, spelled with a 4. Really? What are they taking their time for? What is wrong with California? Next, a family of Idaho students murdered in the Idaho case involving Brian Kohberger. Well, a couple of them want to sue the Washington State University. So let's talk about the facts, and then we'll talk about the likelihood of success here. So the parents of Kaylee Gonzalez, one of the 4 University of Idaho students, fatally stabbed back on November 13th of 2022, have indicated their intention to file a civil tort claim against the Washington State University, where Brian Kohberger was enrolled as a student at the time of the charges. At the time of the murders. Now, Steve and Christy Gonzalez, represented by their attorney, Shannon Gray, stated that the action seeks accountability and greater transparency regarding reports of Kohberger's concerning conduct prior to the murders. The family emphasized that the litigation aims to identify institutional shortcomings and prevent similar incidents in the future. Now, as most people know, Kohberger pled guilty back in 2025 to 4 counts of murder and received consecutive life sentences without the possibility of parole. He resided in the University of Housing there in Pullman, Washington, approximately 10 miles from the crime scene in Idaho. Now, investigative records released following his sentence revealed multiple complaints from WSU students and faculty about the behavior during the fall of 2022. These included allegations of condescending and disrespectful interactions with female students, physical obstructions of exits, and expressions of interest in topics related to criminal intrusion. Well, faculty members reportedly expressed concern about his potential for future misconduct, leading to his removal from the teaching assistant position and a loss of funding in December of 2022. Now, a preliminary tort claim notice was submitted on behalf of the Gonzalez family and initially the family of the victim, Madison Mogan, in May of 2023, which is simply a notice to preserve their right to proceed. Now, as of November 2025, the Gonzalez have advanced towards some form of formal litigation with WSU, though it remains unclear whether other victims' families will participate. So what are the potential causes of action? All right. So as WSU, the Washington State University of Pullman, is a public institution, any civil claim must comply with the procedures for actions against governmental entities under the applicable law there in Washington, which means that they would have to waive sovereign immunity and try to hold the state and its agencies liable for tortious conduct to the same extent as private parties. Anyway, the primary cause of action would likely be negligence, requiring proof of 4 elements. 1, a duty owed by WSU to the victims, breach of that duty, causation, and damages. Now, what duty was owed by WSU to students that didn't attend the university? A legal one, not some moral, a legal duty. Think about that. Anyway, the central legal question is the existence and the scope of a duty, right? Washington courts recognize a limited special relationship between universities and their students, imposing a duty to exercise reasonable care to protect students and foreseeable harm caused by other students, but only in the context of an on-campus activity or university-controlled event. And there's case law to support that. No such duty extends to off-campus conduct or to third parties who are not enrolled students. Here, the victims were students at a different institution, and the murders occurred at an off-campus residence in a completely other state, rendering it highly unlikely that WSU owed a direct duty to protect them. Well, let's get creative. What's another alternative theory? A duty to control Kohberger or to warn potential victims? I don't know. I don't think so. Washington imposes a broader duty to protect identifiable third parties in outpatient psychiatric treatment settings where a special relationship exists, but universities generally do not assume custodial control over graduate students sufficient to trigger a duty to prevent off-campus criminal acts against non-students. So what is the likelihood of success? Well, precedent strongly suggests limited prospects for success on the merits. Washington law imposes no general duty to protect third parties from criminal acts absent a special relationship or custodial control, and universities' protective obligations are confined to their own students during these school-related activities. So the absence of any known prior connection between Kohberger and the victims, combined with the off-campus and cross-jurisdictional nature of the harm, further weakens foreseeability and proximate cause arguments. And so while the complaints about Kohberger's behavior were documented, they did not include, as far as we know, explicit threats of lethal violence toward identifiable individuals outside of the university community. Even if a novel duty were argued, qualified immunity protections for public entities and discretionary functions could bar liability straight out. Similar claims against educational institutions for failure to prevent off-campus violence have rarely succeeded absent a clear custodial oversight or direct university involvement. And for wrongful death action in Washington state, the statute of limitations is 3 years from the date of the death applicable, and survival on wrongful death claims under the Washington Code. Now, the death occurred in November 13th of 2022. Thus, the standard limitations expires on November 13th, 2025. Coinciding closely with the family's November 2025 announcement. Yeah, the statute of limitations may have run. Now, they may have filed suit, but once that becomes publicly available, we'll try to figure it out. Anyway, claims against state agencies, including public universities, require presentation of a tort claim form and a 60-day waiting period before filing suit. And the limitations period is told during the waiting period. The family's 2023 notice preserves compliance, and any lawsuits filed promptly in late 2025 would appear timely, though procedural missteps could still jeopardize this action. So in summary, though, while the family's pursuit reflects a desire for institutional accountability, establishing, Washington, is somehow responsible, the precedent on a duty and foreseeability presents substantial obstacles to prevail. Bottom line is, it's not going to succeed. And unless Washington State University, out of the goodness of their hearts, wants to cough up some money, which kind of goes against their duty to their state and their school to just give away money for something that they're not responsible for, that's the only way I see that the Gonzalez recover any money. Now, my heart goes out to the Gonzalez, but the case is over. I mean, Kohberger's been sentenced. He'll never get out of prison. There's civil penalties against him, so hopefully he never profits from what he did. But to go after the school, I mean, it'd be one thing if the crimes took place at the school and the school knew that the security system sucked and that's how somebody got in, then that would be a viable claim. But to simply say that Washington should have warned people, that nobody knew that these people even existed, there were no identifiable threats to these people, Washington State University shouldn't pay a dime to the Gonzalez family. Like I said, my heart goes out to them, but legally they are on very thin ice. Next, a story about a fugitive sex offender. Took 16 years to figure out. Well, because maybe they thought he was dead. So in a twist that proves that some people really will go to any lengths to avoid paperwork, a 76-year-old convicted child pornography possessor from Florida has finally been apprehended in Indiana after spending 16 years as a self-declared ghost. Please let me introduce Gary W. Howard. Sentenced in 2010 in Pinellas County to lifetime probation supervision following conviction of 22 felony counts of possessing child sexual abuse materials, that's inappropriate pictures, simply walked away from supervision shortly after his release from custody. To cover his tracks, authorities say that Mr. Howard orchestrated an elaborate vanishing act. He abandoned a rental car near Mauzy Lake, M-A-U-Z-Y Lake in Kentucky, leaving behind just enough clues to convince investigators he ended his own life. The scene, officials later concluded, was completely staged, an apparent attempt at the world's least convincing suicide note without the note. For the next decade and a half, Howard successfully blended into quiet civilian life near Indianapolis, presumably enjoying the rare privilege of not having to check in with a probation officer every month. The comfortable anonymity ended this week when members of the U.S. Marshal Service Great Lakes Regional Fugitive Task Force, acting on a tip linking Howard to some local relatives, placed the residence under surveillance. Officers watched the elderly fugitive step outside and arrested him without any resistance. Now, according to the marshals, Howard's first words upon being cuffed were along the lines of hoping natural causes would claim him before the long arm of the law did. Fate, it seems, had other plans. Howard remains in custody in Indiana, awaiting extradition back to Florida. There he faces, obviously, revocation of his probation. And since he basically just walked away from it, we know that he's going to go to prison. They're not going to revoke his probation and reinstate it now, are they? No. Maybe in California, but not Florida, which obviously he's going to wind up behind bars for years, plus up to 32 new charges for failing to register as a sex offender during his extended sabbatical. Now, Indiana police have indicated that they intend to file their own related charges before sending him back to Florida. Now, stark reminder that even the most theatrical exits rarely fool forensic investigators forever, and that 16 years is an impressively long time to dodge a lifetime registration requirement. But eventually, it happens. They show up. Had a guy years ago, I swear, all ready for trial. Guy disappears. And got a call many, many years later. I was like 10 or 12 years later. Same type of thing. Disappeared. Somehow they found him. Back in court. May have worked to his advantage because I think they were having trouble finding witnesses at this point. So I think it all worked out. Next, you should be outraged. Okay, I am outraged. A married mother and a school employee admits to plying an 11-year-old boy with caffeine so she could repeatedly do things to him. Because a grown adult woman had to drug a child to stay awake for her sick attack. Okay. Now, in a case that exposes the most depraved betrayal of trust imaginable, a 44-year-old Connecticut school worker, married mother of two, has pleaded guilty to federal charges of coercing and sexually assaulting an 11-year-old boy, deliberately feeding him caffeine to keep the terrified child awake while she preyed on him in her car. Please meet Allison Kranick, a former paraprofessional and administrative assistant in the state's public school system. She confessed Tuesday to federal charges of coercion and enticement of a minor. Prosecutors revealed the horrifying detail that this adult woman, entrusted with the care of children, deliberately supplied the boy with caffeinated drinks because her chosen victim was only 11 years old and naturally fell asleep during the late night assaults. Over the summer and fall of 2022, Kranick groomed the child through thousands of messages on Snapchat, text, and Discord, more than 4,700 in just 4 months, luring him to sneak out of his home after midnight. She then drove him to remote locations, including the parking lot of the Horace Porter School, a facility serving children as young as pre-kindergarten, where she sexually assaulted him on at least 14 separate occasions. To ensure her 11-year-old victim didn't doze off during these prolonged attacks, Kranick callously pumped him full of caffeine, a chilling calculation that lays bare how a fully grown woman had to chemically manipulate a 6th grade boy's body just to satisfy her predatory urges. She even dangled gifts, Apple AirPods, and a pellet gun as further enticement. Now, arrested by state police in 2023 after the boy finally disclosed that they had had sexual intercourse in her car, Kranick was released on bond, only to be immediately rearrested for allegedly violating conditions by contacting a 13-year-old girl on Snapchat. Federal authorities over the case in 2024 after uncovering the staggering volume of predatory messages on Discord, which the pair switched to when the boy feared a family member would check his phone. Kranick, who regularly posted loving photos of her own children on social media, was fired from the E.O. Smith High School once the allegations surfaced, and the Columbia School District called the revelations a great regret, stressing that educators are entrusted to protect students, a duty that Kranick grotesquely violated against one of the most vulnerable children in the system. She now faces a mandatory minimum of 10 years in federal prison and up to life behind bars. And guess what? Her sentencing will be held in February of next year. And there's still state charges as well. But what have we talked about before? When you got state and federal charges, you got to do the federal charges first because you don't want those state charges coming in your criminal history category and going to jack up your sentence. So anyway, you got to, at least those attorneys were looking out for in that regard. Now, obviously, the sheer depravity of an adult woman systematically targeting and drugging an 11-year-old boy she was paid to help educate has left investigators, prosecutors, and the community kind of, disgusted. I don't get it, ladies and gentlemen. An 11-year-old boy, I don't know. Just speaking from my own experience, 11-year-old boy, when I was 11, I just wanted to ride my bike, ride a skateboard, play with my friends. But to have a 40-something-year-old teacher come after you at 11, this is the definition of a pedophile. A pedophile goes after prepubescent children, ladies and gentlemen. 11-year-old boy, more than likely prepubescent. Ms. Kranick had a file. Bottom line, gross, disgusting. Hope she never gets out. Hope that she never is around her children again until they're at least 18, and hopefully never around her grandchildren if she ever gets out to enjoy them. Unbelievable. If there's not a greater segue into why you need to go to crimetalksearch.com, go check out that everybody's coming in. Someone's going to watch your dog, do a background check. Someone's going to watch your kids, do a background check. Do your due diligence. Next, how about a former South Carolina lawmaker gets arrested for, doing bad things to his clients. Where have we heard this before in South Carolina, right? So in a development that has stunned observers of both legal and political circles, former Democratic state rep Marvin Pendarvis appeared in federal court Tuesday for an arraignment on a sweeping 10-count indictment involving serious financial crimes. Now, the charges, which include multiple instances of wire fraud, aggravated identity theft, and money laundering, paint a somewhat disturbing picture of an alleged misconduct by a once prominent public figure and practicing lawyer. So, federal prosecutors accuse Pendarvis, who specialized in personal injury law, of systematically deceiving his own clients by forging their signatures on settlement documents and diverting hundreds of thousands of dollars in awarded funds directly into accounts he controlled. Authorities claimed in at least 4 separate cases, Pendarvis pocketed more than $532,000 in settlement proceeds intended for his clients that he was obviously representing, funds that were never distributed to those entitled to them. Following the proceedings, a plea of not guilty was entered on Pendarvis's behalf. The U.S. magistrate judge released him on a $50,000 unsecured personal recognizance bond, allowing the former legislator to remain free pending trial. Now, the indictment, unsealed on November 6, marks a dramatic fall for Pendarvis, whose law license was suspended by the South Carolina Supreme Court back in May of 2024. He subsequently resigned his seat in the state house back in September. And if convicted, he faces a severe consequence of up to 20 years of imprisonment on each wire fraud and money laundering count, plus a mandatory consecutive 2-year sentence for every aggravated identity theft conviction. Now, this investigation originated with the Internal Revenue Service, the Criminal Investigation Division, underscoring the breadth of financial irregularities allegedly uncovered. Needless to say, his colleagues have expressed profound dismay at the allegations, which strike at the heart of professional ethics and public trust. The case serves as a little sobering reminder of the potential consequences of those entrusted with both legislative authority and clients' welfare are accused of exploiting that trust for personal gain. Pendarvis's next court appearance has not yet been scheduled, but the Department of Justice has indicated that the prosecution intends to move forward aggressively. So, what can you say? I've always said this, and they teach you this quite early, particularly when it comes to ethics. Now, we know as politicians, they have no ethics, right? But hopefully as lawyers, you have ethics you need to follow. But the general rules are, one, obviously communicate with your client, so they can't say that you abandoned them. So you provide them with what's, regular updates, pleadings in the case. So they always know what's going on. You communicate with them and you tell them this is what the offer is going to be, or this is what the settlement's going to be, right? Because you can't settle unless the client gives you authority. If you don't do that, you got problems. The next one is don't sleep with your clients. Creates kind of conflict, right? Does it not? Not good. And the third one is if you follow these simple rules, you can probably keep your law license, right? Communicate with your clients, don't sleep with them, and don't steal their money. If you do that, you can probably make it through your law career pretty unscathed, all right? But when you steal your client's money, you're going to lose your law license and you're going to go to prison. What can you do? Next, a former Olympian indicted on federal charges for murder and drug trafficking. Well, that's something you don't hear every day. Well, on November 19th, the United States federal authorities unsealed an indictment against Ryan James Wedding, a 44-year-old Canadian citizen and former Olympic snowboarder, accusing him of leading a major transnational drug trafficking organization responsible for multiple murders and the importance of massive quantities of cocaine coming into the United States. The charges announced jointly by Attorney General Pam Bondi and FBI Director Kash Patel at the Department of Justice include charges of conspiracy to distribute and export cocaine, murder in connection with a continuing criminal enterprise, witness tampering and retaliation, and money laundering. Now, Wedding, who represented Canada in the men's parallel giant slalom back in 2002 Winter Olympics in Salt Lake City, where he finished 24th, is alleged to direct an operation that imports approximately 60 metric tons of cocaine annually from Mexico through Los Angeles, and ultimately generating profits estimated to be in the billions of dollars. Now, authorities state that the organization also traffics fentanyl and maintains close ties to the Sinaloa cartel, which is believed to be providing wedding protection in Mexico, where he is thought to currently be hiding. Prosecutors accuse Wedding of ordering the March 2024 assassination of a U.S. federal witness in Medellin, Colombia, to prevent testimony against him. A separate $2 million reward has been offered for information leading to the arrest of those directly involved in the killing. And to date, more than 35 individuals have been indicted in connection with this criminal enterprise. Now, the investigation has resulted in the seizure of $3.2 million in cryptocurrency and over $13 million in other assets. Now, the FBI has placed Wedding on its 10 most wanted fugitive list and is offering a reward of up to $15 million for information leading to his arrest and conviction. He's described as a white male, 6 feet 4 inches tall, roughly 230 to 250 pounds, fluent in English and Spanish, and known to frequent Mexico. Now, the Department of Treasury has imposed sanctions to block Wedding and his associates from the U.S. financial system, aiming to disrupt the network's operation. And authorities described the case as one of the most significant narcotics and violence investigations in recent years, emphasizing the organization's role in fueling the ongoing fentanyl crisis and related violence across North America. So what do you do with that one, ladies and gentlemen? An Olympian on the run in Mexico, apparently with the cartel that's supplying him his drugs. I don't know. What do you do with that guy? Well, we'll see. We'll see if they'll get him. He's obviously been indicted. If he comes into the United States, they'll get him. If he comes in contact with the police in Mexico, maybe they'll get him. But since Mexico is pretty much a failed state run by the cartel, I don't think he'll have much to worry about. Unless, of course, he becomes too much of a liability for the cartels. Probably won't happen, but you'd be surprised. You know, when you do these proffers, so to speak, and you think of these cartels, the federal government knows exactly where these people operate. It's amazing. And then they'll pull out an iPad and they'll show you, and this cartel, this drug enterprise, will literally be run out of a tin shack in, Nayarit, Mexico, or something along those lines. They know where it is, but they can't stop them. So obviously it kind of goes to show the whole war on drugs things hasn't exactly worked great here. It's like playing whack-a-mole. You arrest somebody, the cartel sends over expendable people to move the drugs, and when they get arrested, they go to prison. Cartels don't care. They're expendable. But the people that are up here live under the threat that their families will be killed by people in Mexico if they snitch or provide information on the cartels. We'll see what will happen here. We've seen a little bit, off the coast of Venezuela, killing the boats, alleged fishermen, although I don't see a whole lot of fishing gear when they blow up those boats. But we'll see if they're going to go after the cartels here soon. I mean, if you're going to have a war, you might as well go straight to the source instead of playing whack-a-mole trying to prosecute everybody that comes across the border with pills or cocaine, whatever. We'll see. Well above my pay grade, that's for sure. Next on the docket, this day in legal history. On November 20th, 1789, New Jersey ratifies the Bill of Rights as a set of 10 fundamental amendments to the United States Constitution. That's right, the first state to do so. The state also ratified an amendment on federal representation, which ultimately failed. Additionally, New Jersey rejected an amendment on congressional salaries, which would eventually become the 27th Amendment more than 200 years later. On this date, November 20th, 1787, the Federalist number 8 is published in the New York Packet. Alexander Hamilton's essay, The Consequences of Hostilities Between the States, appears. warning that disunion would lead to standing armies and constant conflict among rival American states. The paper becomes part of the Federalist, a central work in the constitutional ratification debate and its later constitutional interpretation. On November 20th, 1861, pro-Confederate convention in Russellville claims Kentucky seceded from the Union. That's right. A group of Confederate sympathizers meeting in Russellville, Kentucky, adopts a Confederate Constitution of Kentucky and an ordinance of secession purporting to withdraw Kentucky from the Union. Although the official state government in Frankfort never seceded, the Confederate government in Richmond recognized Kentucky as its 13th state. Yeah, that didn't quite work out too well for him, did it? No. And next on the docket, our quote of the day. Here's a thoughtful legal quote. How about this? If there were no bad people, there would be no good lawyers. Think about that for a second. Charles Dickens. A little bit of a reminder of the adversarial yet vital nature of the legal system. And finally, our dumb criminal of the day. Now, in a hair-raising tantrum that lands a San Diego man in prison for 6 years, let me explain. In a decision that has left stylists across the country breathing a collective sigh of relief, 28-year-old August Marriott was sentenced to 6 years in state prison for transforming a routine "sorry, you're late" into a full-blown salon meltdown worthy of a reality television's most unhinged moments. Now, the incident, captured on video that quickly achieved internet infamy earlier this year, showed Marriott hurling shampoo bottles like a disgruntled pitcher and unleashing a torrent of verbal abuse upon a Great Clips employee in Santee after they politely informed him that arriving 60 minutes late for a haircut appointment forfeited his spot in the chair. Well, the deputies from the San Diego Sheriff's Office were summoned to the Mission Gorge Road location, but Marriott, evidently prioritizing flight over fight, sped away before law enforcement could arrive. Thanks to an alert public, they recognized the now viral clip. Police were able to track the fugitive barbershop belligerent down. Initially arrested in February on a menu of charges including assault with a deadly weapon. Apparently those shampoo bottles qualified. Anything can be a deadly weapon. Vandalism and, yes, the old parole violation. Marriott posted bail after entering a guilty plea that acknowledged both the assault and a prior strike conviction. Freedom, however, proved short-lived. Rather than return for sentencing like a responsible adult, Marriott opted for an impromptu cross-country adventure, fleeing to Florida, where local police promptly introduced him to Southern hospitality of the handcuff variety. Marriott was extradited back to California, where a judge this week decided that 6 years was the appropriate timeout for someone who treats hair care scheduling with the gravity of a declaration of war. Now, observers note that while most customers simply reschedule when running late, Marriott's dramatic interpretation of a bad hair day has now secured him a lengthy stretch with state-issued grooming standards, and one can only assume prison barbers run a very tight appointment book. Yes, sir, you are a dumb criminal of the day. Why can't people just be nice? What does it hurt to be nice? It doesn't. Hell, he probably could have got his hair cut. All right, that's all we have for today, ladies and gentlemen. I hope you enjoyed the show. And remember, the Constitution matters.